Hello, everyone. My name's Eric Maples, and I'm going to take the next couple minutes and this little bit of time to talk to you guys about what could be found within my critical assignment essay that we had to write here in this Journalism 320 Media Law and Ethics copyright class. And this is just going to be the presentation. I'm going to give you guys some background information on the cases that I studied, as well as how they go along the same lines, and some differences that they do share at the same time. Again, this is my critical assignment presentation for Journalism 320, Media Law, Ethics, and Copyright. The first case that I had the opportunity to take a look into was the Nebraska Press Association versus Stewart of 1976. To give you guys some background information on this case, 6 people were killed in the state of Nebraska upon the law and the police searching for a suspect for about 48 hours. They were able to find a suspect and detain him. And upon questioning, he did give a confession admitting to killing all 6 of these people. Upon giving this confession, Judge Hugh Stewart held the confession for the trial. He felt that by holding this confession from the trial, it would give the suspect a more fair trial, and the jury and the defense would have to prove that the suspect did indeed do what he said that he did. So only Judge Hugh Stewart had this information. And upon the press and the Nebraska Press Association finding out that Judge Stewart had withheld this information, they took this case to the Supreme Court. The Supreme Court did vote in favor of the Nebraska Press Association. They stated that they felt that Judge Hugh Stewart did violate the First Amendment. They said, quote, prior restraints on speech and publication are the most serious and least tolerable infringement on the First Amendment rights. Chief Justice Berger also noted that Judge Stewart could have taken a better approach in ensuring a fair trial by simply moving the location of the trial to a less exposed area of intense public scrutiny. Or he could have simply let the media attention around the trial die down before having the court case. What I feel was violated in this case, as far as ethical values are concerned, are honesty, fairness, concern for others, and law-abiding. Judge Hugh Stewart failed to remain honest and fair when he decided to withhold the confession information. This is information that could have been used to help the jury make their decision and add on to it, not make the whole decision for them. He violated a concern for others because it is possible that this suspect could have been proven innocent and let go and been free, but now Judge Hugh Stewart was the only man that had the information to be able to help the jury come to that conclusion that he was indeed guilty. And I feel that he did not abide by the law because he withheld the information, which we all know is public information, and that does fall under the First Amendment. The next case that I had the opportunity to look into was the case New York versus the United States from the year 1971. Some of us, or some may not, know this case as the Pentagon Papers. The New York Times published articles within their publication, their newspaper publication, releasing information from the government in regards to why we were in Vietnam for the last 6 years. Upon publishing at least 3 or more articles, the New York Times received a restraining order from the United States government demanding that they stop all publication of the Pentagon Papers regarding Vietnam. Upon receiving this restraining order, the New York Times sued the United States and took them to the Supreme Court. They felt that their First Amendment rights were being violated, and upon the Supreme Court voting, the justices did come to the agreement on a 6-3 vote in favor of the New York Times that indeed their First Amendment rights had been violated. The United States government stated that they felt that the New York Times was exposing our national security and putting us at risk. The Supreme Court did not feel the same way. They felt that information should be disclosed to the public, and they felt that it was public information that was required. Why I feel that these cases go along the same lines is because clearly they both deal with the First Amendment. Why I feel that they are different is because in the the Nebraska Press Association, versus Stewart, it was the law and the judge that was withholding the information from the public. They did not want us to receive the public information that we needed to be able to make a correct jury decision. Within the New York Times versus the United States, it was actually the government that was, or it was actually the public that was giving information to be able to help better our public understanding of why we were involved in a situation and a war that many people did not understand. On one end, with the New York versus United States, the government did help us. The Supreme Court did help the public by granting the information to the public and allowing us to be able to discuss it. Within the Nebraska Press Association, the law, on the other hand, wanted to withhold the information so that the public did not get the proper information that they needed in order to make a correct decision. Again, this was my Journalism 320 Media Law, Ethics and Copyright critical assignment presentation. I hope you guys enjoyed, and I hope you guys could take a thing or two away from today. Have a good break, guys.